welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Gehringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And today we're going to start a two-part podcast series on the recent court ruling. And by recent, I mean something that happened almost a year ago in 2017, but that many of you are now working on and trying to understand, especially if you have animal operations. I thought I had done a podcast on this court ruling earlier, but apparently I hadn't when I looked back. So I decided, okay, we'll start with the basics. Today, we'll talk about the court ruling itself. And in our next podcast, which will go up next week, we'll talk to Ashley Ellickson, who used to be with the University of Maryland as a legal specialist here and is now with United Dairymen of Arizona, to talk sort of about how this court ruling is being implemented and some of the problems from her perspective, working with the livestock industry and trying to get it implemented, and, you know, what producers need to be aware of as they're putting it in, you know, trying to implement it and trying to get in good with the law. So we'll kind of get started. If you can't gather from the title, we're going to talk today about the court ruling with the Comprehensive Environmental Response, Compensation, and Liability Act of 1980, also commonly referred to as CERCLA, or many of you may know it as the Superfund law. We're not going to talk about it in context today as the Superfund part. We're really going to talk about it in response today to the reporting requirements that many of you will be having to undertake. There's another law that's a part of this, the Emergency Planning and Community Right to Know Act of 1986. The idea with this law, or IPCRA as it's known, is that basically emergency first responders, communities, people, emergency planners in the community should be aware of what, you know, hazardous chemicals are being stored in their areas, of what's being released into the environment. So first responders, emergency planners are able to understand what's there, have the equipment necessary in case it comes about. And if somebody reports an incident, they're able to know where that incident could be coming from because they have it mapped out and they're aware of the location. Now, with that said, we're going to go back to 2008. In 2008, EPA created an exemption for all animal operations in the U.S., eliminating the requirement that they would potentially have to report ammonia and hydrogen sulfide emissions under CERCLA and IPCRA. Now, with IPCRA, the one thing they didn't do was do away with it for larger livestock farms. We're really not going to focus on IPCRA today because although the challenge was to both CERCLA and IPCRA, as we're going to talk about, IPCRA is still not decided yet. So we're going to leave IPCRA off to the side, and we're only going to talk over here about CERCLA. At some point, we'll talk about IPCRA and that court ruling once it happens. IPCRA, the idea was, or CERCLA, the idea was, we didn't need to know this information. There was no ability, according to EPA, that EPA would ever take a response based on anything reported to them, so they created the exemption. Shortly after it was created, environmental groups and animal welfare groups challenged that exemption in federal court. When that challenge happened, EPA looked at the court and kind of said, you know, we understand we're probably not going to win. We need to go back. We need to reevaluate this rule and come up with a better rule. Now, that was in about 2010. Fast forward to 2015, nothing had happened. Those same groups sought to reopen the case with the D.C. Circuit Court of Appeals to have the D.C. Circuit start forcing EPA to do something. I mean, after 5 years, if nothing's happened and it doesn't look like anything's going to move forward, you can see their point. They wanted to make sure something was actually going to happen. At that point, the court came back. They looked at these laws and they said, okay, for CERCLA, let's look at this ruling. And the idea here had been that, let me scroll down in my page so I can get to where I'm supposed to be at. To EPA, these releases were ongoing. None of them were going to be because of an emergency response situation and because of that, an emergency response situation was unlikely. And that's where these challenges came into play. These environmental groups, animal welfare groups wanted to know where these releases were happening on review by the court. So now we're up to 2015. The court's actually, or here, 2017, the court's actually giving us an opinion, telling us what they say. The court looks at this exemption to see if it's a reasonable interpretation of what the law allows. So we have to look at laws like CERCLA as a blueprint. Congress passes this law as a blueprint. It goes to EPA or another agency, depending on, who has jurisdiction over the law. And at that point, the agency can only act within the bounds that Congress has set. So EPA can't go out and just create willy-nilly exemptions. It has to fall within the scope of the law, and the law has to allow these exemptions to happen. If nothing contradicts that interpretation in the law that EPA's been given and EPA has created, then the court will not step in and not interfere. The court will allow it. Even though it may not like the exemption, it will continue to allow it because it's not going to replace its judgment with EPA's judgment. In that case, they're the experts, the court isn't. In this case, the court disagreed with all of this in the creating of the exemption because EPA's arguments that the law actually gave it the authority to create the exemptions didn't really give it the authority, according to the court. The court viewed these statutes as straightforward with a list of exemptions, and nothing in the statute gave EPA this authority to create the exemptions beyond what was spelled out in CERCLA. EPA comes back and argues, okay, if we don't have the authority to do it, this falls under the de minimis doctrine. The de minimis doctrine is this idea that certain things that laws could force you to have to do are so small and so trivial, you shouldn't have to do them. So, we could look at this and say the burden on you is so high for the information that EPA will get out of it. In this case, the court looks at it and goes, the de minimis doctrine really doesn't apply because EPA, in your comments alone, you pointed out areas where this reporting information would be useful and you actually do need it. You also had public comments that pointed out when this information would be useful. Emergency planners had pointed out that by having this information, they would be able to map it, be able to show. So when someone calls in and reports a smell or an odor they're unaware of, they may be able to point out, oh, it's an ammonia coming off a poultry farm or a dairy or, a feedlot or a hog farm or something to that effect. So with that said, the court basically goes, no, this is not going to work. It's not de minimis. You have comments that say this is going to work. This is not going to work. So the agency or the court basically strikes down this final rule that EPA's done, and EPA has to go back to the drawing board and kind of start looking at how to interpret this rule. In issuing this, the court points out, as EPA kind of made the court aware of, calculating these livestock emissions are really hard. We don't have really good sound science that will show us this is exactly what's coming off the farm. We have, as you're going to see if you've gone to EPA's website and looked at this, we have some formulas where you can kind of get an estimate or an average as to what that would be under certain conditions. But we have to take into account that ammonia emissions are going to change based on weather, diet, number of animal units on the farm, and other conditions. How are we storing the manure? How are we handling the manure? What are we doing at that point that would potentially cause more or less ammonia to go into the environment? You may notice I've never said hydrogen sulfide except for a few times. For the most part, we're only concerned, as we're going to talk about next time, with the ammonia reporting requirements. We're not truly concerned about the hydrogen sulfide reporting requirements at this time. The court points out that all a livestock farm has to do is report a continuous release and do an annual continuous release report with the National Response Center. For those of you that may have started looking at this is what we're going to talk about in the next podcast. How does this process exactly work, and how are we exactly going to do this? So why do you care about this? Well, if you're a livestock operation in the state of Maryland, have a large number of poultry, dairy cows, sheep, goats, cattle. Now, we're talking thousands of animal units in most cases. I applaud you if you want to go get into this and dig in the weeds. I'll put the link, TPA's website, up here in our fact sheet we put together on this. But you need to go in and look at the livestock calculators to make sure you're going to fall under this reporting requirement. And like I said, this is what we're going to focus in on the next podcast. This is not an easy proposition out there. You're going to have to monitor these things to be able to understand how changes on your farm are going to impact your emissions releases. You're going to need to pay attention to the tools. I make this sound more onerous than it actually is. In the end, next week, we're going to talk about a lot of how this reporting is going to happen, at least initially, and then potentially maybe see what's going to happen down the road. There's still a lot, even this court ruling happened almost a year ago. We're still a long way from actually understanding what the long-term impacts of this court ruling are going to be, how to change this. But as it stands now, EPA does not have the authority to at least create an exemption under CERCLA. We're still waiting to see what that exemption is going to be under IPCRA. The exemption may or may not be upheld. That's still up to the court to decide. Until then, I have, documents down at least to show you where the summary of this podcast is at, so you can read it. Put a link to EPA's website. If you have any questions on this or thoughts on additional podcasts that should be put together, please let me know. My contact info is down below, but for those listening and don't have access to a computer right now where you can see it, my contact info is lgoering@umd.edu, or you can tweet me at aglawpaul. And until then, enjoy the rest of your day.